I now need to tell you about the doctrine of material differences. This doctrine is contained in section 30 clause 4 of the Trademarks Act. According to section 34 clause 4 of the Trademarks Act, if the condition of the goods which are being resold is changed or impaired, or if there are any other legitimate reasons for the trademark proprietor to oppose the resale of those goods, then the immunity under section 30 clause 3 would not be available. The question is, when are the goods considered to be changed or impaired, or what are the legitimate reasons that a trademark proprietor can take to oppose the resale of the goods? It is possible, though it is not settled by courts in India, that the lack of warranty or the lack of change in the condition of the goods will be considered a material change or impairment which would allow a trademark proprietor to oppose the resale of the goods. I will take an example from another jurisdiction. In the US, Nestle chocolates were sold in a particular condition. Nestle likes its chocolates to be in perfect condition when they reach the consumers, and thus it maintains the temperatures of its chocolates at a particular level to ensure that the chocolates are not melted when they reach the consumers. In that particular case, the chocolates which were being sold through another channel of goods, because of which the chocolates melted, since the defendant did not maintain the temperature of its trucks which were transporting the chocolates at a particular level. Owing to this, Nestle sued that defendant and said that the condition of the goods was materially impaired and this was causing loss to Nestle. The court said yes, this amounted to a material difference or a material change, and thus held in Nestle's favor and said that the doctrine of exhaustion of rights will not apply. What will be these changes or impairments or legitimate reasons is an open question which again the Supreme Court will probably answer when the Samsung case is decided in the near future. Let's now move on to the next doctrine. I would like you to read section 30 clause 2 clause E of the Trademarks Act, section 28 clause 3 of the Act, and section 124. Before proceeding, please have a look at these sections. According to section 28 clause 3, it appears that if there are two persons who are registered proprietors of a trademark, then they will not be able to sue each other. You would be wondering at this stage, how can there be two persons who can be the registered proprietors of the same trademark? After all, section 11 of the Trademarks Act prohibits the registration of a trademark which is similar to an already registered mark. Unfortunately, despite this provision, one finds that the trademarks registry still registers many trademarks which are similar to one another, and this gives rise to a situation where two proprietors are registered for same or similar trademarks. That's why section 28 clause 3 tries to deal with this situation. According to section 28 clause 3, the two trademark owners will not have rights against each other for infringement of a trademark, but they will continue to have rights against all other parties, that is, against the world, with respect to their respective trademarks. This is the doctrine under section 28 clause 3. Similarly, under section 30 clause 2 clause E, a person can take the defense that he or she is a registered proprietor of a trademark and thus he is entitled to use the trademark. I'll explain this concept to you by means of an example. Let's say there's a person who is the registered proprietor of the trademark Gopal Sweets for sweets. Consider that another person goes to the trademark registry and registers the trademark Gopal for sweets. Is it possible for the first proprietor to stop the other proprietor from using the trademark Gopal? It would seem from section 28 clause 3 and section 30 clause 2 clause E that this is not possible. The subsequent proprietor can always take the defense that being a registered proprietor of a trademark, it cannot be stopped from using the trademark for which it is registered. But there is a catch here. You now need to see section 124 of the Trademarks Act. Section 124 contemplates a situation where a suit for infringement of a trademark is filed against the registered proprietor of a trademark. This itself is our first clue. It seems that the suit for infringement of a trademark can be filed against the registered proprietor of a trademark. Secondly, section 124 provides that if a suit for infringement of trademark is filed against a registered proprietor of a trademark, proceedings for finding that the trademark is invalid can be instituted by the first registered proprietor. That is, the plaintiff can say that the defendant's registration is invalid. This may be for several reasons, such as section 11 of the Trademarks Act or section 57 of the Trademarks Act, which deals with non-use. This would mean that since the defendant's registration is under challenge, the court would stay the proceedings and allow the plaintiff to file appropriate proceedings for finding that the registration of the trademark is invalid. But this leads us to the question as to what happens to section 28(3) and section 30 clause 2 clause E. All these provisions have been reconciled by the Delhi High Court in the case of Clinique versus Gufic. Therefore, these provisions need to be reconciled. The Delhi High Court in the Clinique versus Gufic case attempted to reconcile all these provisions. I have culled out the ratio of that decision and I will go through each of these points one by one. First, the Delhi High Court said that there can be a suit for infringement against the registered proprietor of an identical or similar trademark. Secondly, upon the defendant taking the plea of his registration and of there being thus no infringement, the suit for infringement has to be stayed awaiting the rectification proceedings. This means that if the plaintiff files invalidity proceedings against the defendant, then the suit for infringement will have to be stayed. It is important to note that only the trial of the suit will be stayed. This is because of section 124 clause 5, which says that the court remains empowered to pass any interim order, including the grant of an interim injunction. Lastly, and this is important, the court, while passing an interim order, will necessarily have to prima facie adjudicate on the validity of the two competing registrations. That is, the court will have to prima facie see whether the plaintiff's and the defendant's registrations are valid. This is because section 31 of the Trademarks Act specifically says that the registration is prima facie valid in evidence of validity. However, in attempt to reconcile all these provisions, the court will have a prima facie view whether the defendant's registration is valid or not. This, of course, is the opinion of the Delhi High Court, and we are yet to see a decision from the Supreme Court in this regard. However, it does seem that the Delhi High Court has provided a correct answer on the way to reconcile all these sections. Now let's move on to the other limitations under subsections of section 30.